I want to mention. May I please, Lordship?
Deeply obliged.
May I, Lordship? Hearing is, I want to mention, Lordship.
You're appearing for which case? Has your matter been called out?
I am on behalf of the Jagat Santi Shakma. Item number 1 from hearing.
No,
is, Lordship.
item number 1 has not been called out. Yes. So what? You want to pray for adjournment?
Yeah, Lordship. Our engaged counsel has some personal difficulty, Lordship.
Yes.
This is for the part 2 item list, my lord, item 1 for
Yes.
part 2. I am for the respondent number 5 and 6, my lord. 5, 6, and 7, sir.
Okay, so you're praying for adjournment. Not objected?
Not objections, my lord.
Mention is made on behalf of the learned counsel for the petitioner, Mr.
Kindly, ambitious.
M. Bishwas, for adjournment of the matter which is not objected by Ms. Valentina Laldinpui, learned counsel for private respondents, is it?
No, my lord, for the CATC 5, 6, and
Okay,
7.
which is not objected by the respondent, learned counsel for respondent number 5 to 7. In view of the above, list the matter after 2 weeks.
After Puja vacation, Lordship, kindly, on a fixed date, Lordship, we have to come from Guwahati.
Make it after 2 weeks, anytime. Okay. Yes.
Highly obliged.
I seek your lordship indulgence in making a mention
Or make it 3 weeks, after 3 weeks. That will be after pujas. Yes.
for listing on Thursday, my lord, one contempt case.
Which one?
Unlisted, my lord.
What's the urgency?
My lord, in this matter, the state respondents and the petitioners have make outside court settlement. So we have to withdraw this according to the
Oh,
terms
okay.
of the settlement.
List it tomorrow. No, tomorrow is DB day, isn't
Thursday,
it?
madam, Thursday.
On Thursday.
I'm obliged.
My lord, I would like to make a mention on part 2, item number 3, 8, 9, and 10. With the consent of the other parties, may this matter be listed next week.
I am for the petitioners in these cases.
3, 8, 9, and now in 3,
Or
3
I'm
you are
not-
for
3
the-
I'm not there.
I'm the appellant in item number 3, Lordship.
You're appearing on behalf of whom?
For the respondent number 1 to 4 in item number 3, and
You're appearing on behalf of Lalchandiana Kyangte, your senior, is it?
yes, my lord,
So why is he not appearing today?
he has some personal difficulties.
Like what? You see, especially matters. So you're the what? You're the complainant here.
Yes, my lord. Respondent number 1 to 4, the complainant in MSCT.
Yes. Mention is made on behalf of Mr. Lalchandiana Kyangte, learned counsel for the respondent number 1 to 4 for adjournment of the matter which is not objected by Mr. Johnny L. Tochong, learned counsel for the appellant. In view of the above, list the matter in the next week. Yes.
Obliged.
Or make it after 2 weeks. List the matter after 2 weeks. Yes. Now, then 8 and 9. Is
8,
it?
9, and 10.
Now, yes, Mr. Lalfaqam, you are appearing in all these cases.
Yes, Your Lordship. My understanding is that, Your Lordship, Mr. Lal Chanliana has boil on his thigh.
Oh, okay. Okay. Then we'll adjourn. Again, same order. Learned counsel. Mention is made on behalf of Mr. Lal Chanliana Kyangte, learned counsel for the respondent for adjournment of the matter which is not objected again by Mr. Lalfaqama, learned counsel for the petitioner. In view of the above, list the matter after 2 weeks. Same order, 8, 9, and 10. Yes.
Obliged.
Lordship, if I may, in respect of this item 6, it's a MAC appeal. It has just come back from mediation. This item number 6.
Okay.
So
They couldn't settle?
Yes, Lordship, we are not able to settle the matter.
we were not able
So
to settle through mediation, but if Your Lordship permits, if I may be given just a week's time, I'll consult the branch manager and on the way forward.
Who represented branch manager in the mediation? Someone?
Yes,
One
an
of
officer,
your-
an officer from the office. I don't exactly know her designation, but the one who handles legal matters.
Okay, you will find out. Anyways,
I'll find out.
Mr. Lalfaqama, learned counsel for the appellant is present along with Mr. Johnny L. Thauchong, learned counsel for the respondents. The learned counsel for the appellant has prayed for adjournment of the matter. In view of the above list, how long would you take?
It's just 1 week, Your Lordship, because
List after
rather-
1 week.
yes, deeply obliged.
Admission, item 2.
Yes.
My lord, here the earlier occasion, my senior friend, my lord, is objected the one ground the maintainability of the repression, maintainability. So for that question is arise, my lord. First, the super order, impugn order is there, my lord. Impugn order is, my lord, page 45.
Yes, 45.
Yes, my lord. And this order was passed on the basis of the representation, my lord. Representation is Annexure C, page 35. So the impugn order is not passed in pursuance of order of the civil code. The earlier occasion, senior friend raised the question this because of the order was civil code order, so writ petition under 226 is not maintainable. So this on the basis of the application of the page 35, the order impugn order is passed.
Who did this? So who has made this order? It is
Order passed by
counsel for the petitioners. This page 35 to the district collector.
yes, ma'am.
This letter is made by the
By the lawyer.
counsel for the petitioners.
Council.
This is not an order. This is just.
This is an application. Page 35 is application.
Oh, okay.
On the basis of the application, my lord, page 30, 45, the impugn order was passed.
Okay.
That is,
So what does the impugned order say?
Impugned order says, my lord, they pay them interest under section 30 or 28 and 34 of the LA.
Okay, so you're saying this is an order of the district collector?
District collector, but there, and one CMA was filed by similarly situated person in LA, a LA case. That CMA, this reference court pass an order or land court will pass an order to pay them the interest under section 28.
Where's the CMA? Is it here?
It is here.
Page 25.
It starts from page 28.
Yes.
Relevant portion is page 34. Accordingly, I find force in the application and for the reason stated above, respondent to district collector scholarship is directed to make assessment payment of interest under section 28 and 34 as per land equation and so in a period of 2 months from the district receipt. Thereafter, respondent one NF Railway is to make payment on of the amount so assessed by the district collector within 2 months from the date of assurance. So this order, so thereafter this page 35, the application, the respondent, private respondent similarly situated, so they filed the application under section 28 and 34. But in LA Act and present also the RL also, there is no such provision to file application under section 28 and 34. There is only the provision of file application under section 18, under section 28A and 28A3. There is 3 provision to file application. There is no such provision under the Act to file any application under section 28 and 34. This and this is one aspect. And here the district collector pass an order. This impugn order is page 45 and relevant portion is page 47. From last paragraph, from the above sections, I am satisfied to award the satisfied to the award the petitioner of the instant case statutory interest under section 28 and 34 of LA. So and so, the assessment interest so and so shall be made from the date of possession so and so, so and so, so and so. This order was passed. So far, this order was passed on the basis on an application, not on the direction of any court below. So this question of the maintainability of the retribution does not arise because we are agreed with the order of the district collector. So we are not agreed with any order of the court of law.
You are not aggrieved by the order?
We agree with the order of the district collector.
Okay.
But this-
Now, in the court of law, what does it say? The court says, page 34?
34, they are entitled under section 28 and 34. But these petitioners are different, not on the present respondent.
Oh, so this here, wait,
Here after that, getting that order.
where the petitioner here is different.
Yes,
The name is, his name is not here?
name is my lord is the name is but it was filed by the council. But how the council filed the application, I don't understand. It is not an advocate notice. But here, in some cases, I find that there is advocate is filing a representation on behalf of the client. Advocate can only file the advocate notice, but here they filed the application. So there is no name of the claimant or petitioner is not here or respondent. So far. In CMA 92 and 92 of 2019, the petitioner's name are there, but these petitioners are not included. This present respondent are not included in the CMA. So they themselves stated in their representation filed by the advocate. And I'm reading page 35. In connection with the subject indicated, I would like to state that the following points on behalf of the petitioner. The above LA case number so and so was disposed by judgment ordered 6/3/2014 by the Honorable Reference Court, wherein the Honorable Court was pleased to direct the respondent to NF related to pay compensation of the market value of the land of the petitioner, including solicium so and so, within 16 days, 60 days from the date of judgment. It is pertinent to mention here that said LA case number so and so had proceeded and disposed by the Reference Court in pursuant to the Reference Court application under Section 18 of the Land Acquisition Act. Due to non-assessment and non-payment of compensation for market value of land, the petitioner by the respondent to NF Railway. In respect of the acquisition of land, the construction of railway lines siding to Bhairavi, even though certain amount of compensation in respect of crop damage has been paid as per award of 1 of 2012, Part E Mulkha. In this regard, it would be pertinent to mention that the possession of the land acquired land measuring 52 hectares located at Mulkhang Village Council area, including the lands of the petitioner. Petitioner was taken over by the respondent too.
Anyways, whatever, this is a letter written by the counsel for the petitioners.
So thereafter, the district collector passed an order. This case 47.
Okay, so you say you're appealing against this. Okay,
So
fine.
so this is not this order is not passed by the any direction of the civil court. So this first aspect. Here, my lord, this so far the impugn order is concerned. The apex court in Pusapati versus so and so this it is already observed that so far section 18 and section 28 2028
You know what we can do? We will admit the writ petition. The maintainability, question of maintainability will be kept open and we'll list it for hearing. Then let's see.
Yes,
I think because the way we are going, I think we're going to hear the whole case anyways,
yes ma'am.
isn't it? Then we can come, then we'll have the hearing on the case.
Yes ma'am.
We'll admit, and the question of maintainability will be kept open at the time of
My
hearing.
lord,
I think-
if that is the case, and I do agree with Lordship. My lord, he himself has annexed along with the petition a copy of the judgment and order passed by the civil court. In compliance with this order, the Deputy Commissioner, District Collector has passed the said impugn order. He omitted to
Yes,
mention.
that is true,
If the
but they are not the petitioner.
maintainability of the writ petition is kept
It will be
open,
kept open
Then, my
for
lord.
hearing, isn't it?
that's
Yes.
all right.
I heard Mr. S.K. Medi, learned counsel for the petitioner. Also heard Mr. L.H. Lianshima, learned senior counsel for the respondents, private respondents. Okay. And Ms. Linda L. Fombal, learned additional AG for the state respondents. Having heard the submissions made by the learned counsels, the instant writ petition is admitted and is to be listed for hearing.
On 16 of this month, September 1. Tuesday, it is Tuesday.
The 16th.
Yes, ma'am.
Okay, listed for hearing on 16/9/2025. Full stop. The maintainability of the instant writ petition is kept open and to be considered at the time of the hearing. Yes.
Brilliant.
Obliged.
Item 3.
Well, this petition pertains to the occupation of the petitioner's land by the Bru National Liberation Force returnees under the instruction and with the consent of the state government. However, no payment is made. I mean, no compensation is given to the landowners, the petitioners.
You said that you're the rightful owner.
Yes,
is
my
it?
lord. In fact, we had earlier filed a writ petition, which was disposed of by this honorable court, directing the state government to conduct spot verification. The same was done. And copy of the report was also annexed along with this petition.
What does the spot verification say?
Court verification is found at page 31.
Oh,
Page 31, Annex 4, is the copy of the report submitted by the Deputy Commissioner, Mamit District, my lord.
so what does the report say?
Report says that the land was occupied by
Occupied.
the... yes, my lord. It was confirmed.
So, okay, so is it still occupied as
My
of
lord.
today?
They are there on permanent basis. So reports are there, my lord, for perusal of the court. And in fact, my lord, thereafter also the state government has held under the chairmanship of the chief secretary several meetings. Sometimes they were of the view that compensation was to be given to the landowners.
Is it?
And
Where?
yes, my lord, I will show your lordship at page 50, Annex 7, paragraph 5. I'm not reading the whole thing.
Yes.
Paragraph 5, it was, I'm reading, my lordship purpose. It was reported that the authenticity of the periodic pattas of the petitioners are questionable. It was seen that the periodic pattas do not bear the name of the signatory. Whether the signature was forged or not is not known. In the meantime, the relevant file in the Land Revenue and Settlement Department could not be located. The said file is the main file wherein the government conveys its approval for grant of the periodic pattas. Such being the condition, the meeting suggested that the Deputy Commissioner Mamit shall have thorough investigation of the case and its related matters, like the name of the signatory, concerned assistant settlement officer, copy of the government approval, etc., and submit the report with supporting documents to the government immediately. In fact, my lord, even after receiving the spot verification report from the concerned authority, that is the Deputy Commissioner Mamit, it was questioned. I mean, the authenticity of the
No,
past
was questioned.
was questioned. Accordingly, the Mamit here, page 59, my lord. I'll take your lordship to page 59.
Yes.
Yes, the Director of Land Revenue and Settlement Department wrote a letter to the Undersecretary to Government of Mizoram, Land Revenue and Settlement. With reference to the above, I am sending here with a copy of letter number so-and-so, dated so-and-so, with its enclosure duly received from the settlement officer, Mamit, for kind perusal and further necessary action, my lord. The next page is the type copy. And at page 60 is a letter written by the settlement officer to the director, my lord.
Yes.
With reference to the subject and reference number cited above, I am submitting here with collected paper and other correspondings and reports with respect to allotment of land to the petitioners in WPC so-and-so. These are the petitions filed by the petitioners, my lord. So here is the report.
8 of them.
61. Yes, my lord. 8 of them.
8 of them.
Yes, my lord.
So you're having government approval passes.
Approval, yes, my lord. Everything is there.
So what is this thing stand of the, you have filed a counter affidavit. What do you say?
They
Is
have,
this a
my lord.
report made by the government
Yes,
only?
my lord.
So why aren't you, what is your stand?
My lord, we're saying that there are no connected papers or documents supporting the claim, so the genuineness is still questionable.
No, but here the government has made a report, page 61. 61 is made by whom? It is made by the Deputy Commissioner, is it? Settlement Officer.
Settlement officer, Revenue
Settlement
Department,
officer.
my lord.
So can we dispose of the writ petition with an order to look at page 61, verify the genuineness, and if it is genuine, this thing, proceed with paying for the, as per the prevalent law, that is what, 2013?
Yes.
We can dispose it off.
My lord. And before that, my lord, notification was also issued by the state government on 24th September 2021
Where is that?
at page 56, my lord. I just want to read to your lordship. Page 56, notification. Here, whereas the General Administration Department, Government of Mizoram, requires a plot of land belonging to 8 petitioners and Pula Lai Rupuma in the WPC so-and-so, for accommodation of pro-national liberation front returnees. Now, therefore, the Government of Mizoram hereby grants concurrence to the proposal of direct purchase for all the required land by the State Department for compliance with judgment and order issued by Guwahati High Court, Aizawl Bench. As this is in compliance with the High Court's orders and minutes of meeting dated 1/3/2021, held in the Chief Secretary's conference room, all the procedural of terms and reference of departmental land selection and purchase both cannot be followed. And hence, point number 4 to 9 of the TOR are hereby exempted. These are the notification issued earlier, my lord.
Wait, the third paragraph, as this is in compliance with this minutes of the meeting so and so.
My lord.
All the procedure of terms of reference. What is this? Terms of reference of departmental land selection and
This-
purchase board.
Some
This
certain
procedure, what
conditions
is
are to
this?
be followed. However, the same are to be exempted in the present case because of the order passed by the High Court, my lord.
What is this exempted? In
I-
compliance with the High Court's orders, High Court's order, both WPC 170 and 120 is what for verification?
So you can clarify,
What is the High Court's orders 170 and 120? Are the judgments available? WPC 170 and
no, my lord.
2015?
The judgment is
and-
available, my lord. That
Huh.
is-
Okay,
judgment
170 of 2025, where is the judgment? Page?
Page 23 is the order passed by the honorable court.
Page 23.
23. This is the first.
Okay, this is the first one. What is the
first one.
operative
The
portion?
second one is 120
Let's
of
read the operative
26.
portion. What does it say?
Directing the state government to conduct spot verification.
Spot
And
verification.
if found entitled, let such compensation be paid
Within
within a
3
period
months.
of 3 months.
Okay.
Now, almost 10 years have gone by.
Then there's another WPC 120 of 2016. Where's that? The next page.
26. Page 26.
Page 26, man.
So operative part, what does it say?
Operative part is on completion of the said verification, the respondent number 2 shall thereafter take necessary steps for giving back the land of the petitioner covered by periodic pata number so and so, or in the alternative for payment of compensation.
Okay,
to
so
the
this is
petitioner.
only one petitioner.
Yeah, here only one, and thereafter another followed. So 3, 4 petitions have been filed by different persons, my lord.
But this is 4000504. Then in the verification report, this is there.
Here, my lord,
2017. This
page
person is not
23.
mentioned in page 61,
page 61.
is it? Page 61. Oh, yes, his serial number 8, is it?
Yes, my lord. Tansei.
Tansei.
Yes,
So
my lord.
Tansei is mentioned here. What about the other
Other,
1 to
yes, my
7
lord,
petitioners? They are covered by the
four-
first WPC, is it?
Yes, the first WPC covers four petitioners.
1,
Lalparliana and 3 others.
Or their serial number?
Their serial number 4,
Who are there?
others number not being mentioned. My lord. Starting from
Because-
page 17, my lord. Page 17 is the first WPC 118 of 2013. Here the names of 3 petitioners mentioned. Lal Ompuya,
See, it's not that simple because 3 petitioners are mentioned, but their names are, okay, number 2, serial number 2 is mentioned.
3 also mentioned, my lord. 3
Lalwaya, Rosangliana, okay.
And-
Lalompuya,
Lal Ompuya.
So his case cannot be considered. Who is the counsel here?
I'm all,
For
I'm
all
the
of
counsel
them.
for all of them.
But WPC, one of the petitioners, his case is not mentioned here. If you're going to look as
One
per
is not mentioned,
61.
my lord.
Ah.
Without filing any petition before the court, he was considered by the state government, my lord. He was not my client, my lord. He was not a party to the present case.
Okay, but
That was also mentioned in their order.
this one is not here. In page 61, after the verification, the name of Sri Lalompuya, page 17, is not here. So, because after the verification done by the state respondents, we'll have to rely, I mean, I'm just thinking what sort of order is this court supposed to pass after hearing you? We have to look at page 61.
Yes, my lord.
So only those petitioners mentioned in page 61, that has been verified.
My lord.
It is for the court to look into this verification, for the state respondents to look into this verification report, which is the result
Right, my lord.
of the orders of this court, previous orders. So this page 61, you are going to look into the authenticity of this page 61. Okay, and thereafter proceed by giving the required compensation as per the existing law. I think we can dispose it off like
My
that.
lord, my lord. And as far as the
All the petitioners in the writ petitions are not mentioned in page 61.
yes, my lord. That if need be, I may be permitted to clarify. I shall have to check it because it's been pending for quite some time, for many years, my lord. I cannot recollect how the petitioner number 1 came into existence, Lal Ompuya. And at the same time,
Lalompuya is not here.
his name,
In the other court orders also.
he could be a
And
legal heir to his father somewhere. That
verified,
I will have to
isn't
check
it?
my
Okay. And also,
oh, my lord.
this order you're depending upon. Okay, this mentions 3 writ petitions. Is
Yes,
it?
my lord.
8 petitioners. So look at this notification also, whether, so basically it is your page 61, which
My
is
lord,
the
my lord.
report.
Right, my lord.
And it is a report made by the state government.
Yes, my lord.
So you cannot contradict your report,
Right.
but then if you still need time, we can say that they can verify. However, since you need time, we'll fix another date. Yes, heard Mr. H. Lalsham, Learned Senior Counsel, assisted by Mr. Learned Senior Counsel for the petitioner, assisted by Ms. Ruth Lal Rotfelli, Learned Counsel. Also heard Mrs. Linda L. Fumble, Learned Additional AG, Advocate General, okay, when I say AG, for the state respondents. On hearing the submissions made by the learned counsels, the learned senior counsel has prayed for adjournment of the matter, since the matter is coming up after quite some time and he needs to get some instructions regarding the case. In view of the above, list after 2 weeks. Or when, how long will you take?
Next week also,
Okay, list in the next week.
my lord. Oh, nice.
Item 4 and 5.
Item 4 will file affidavit, my lord.
Yes, so have you filed your counter affidavits? All filed? Readings complete?
My lord, in item number 5, we haven't received any affidavit.
Your Lordship, in item number 5, regarding to item number 5, we have filed our affidavit on 25/8. But my Lordship,
What
we
about
inquired-
4?
Regarding to item number 4,
I'm seeking another 2 weeks' time to file affidavit.
In this case, there is a rate appeal is pending.
Who is appearing for the petition in item number 4? None appeared for the item number 4. Okay, petitioner, while Mr. S.K. Medi, learned counsel for respondent number 6 is present.
3, 4, 5, 6. 3,
For-
4, 5.
Okay, for respondents number 3, 4, 5, and 6. Along with Ms. Vanesiami, learned government advocate for respondents number 1 and 2. Is it?
Yes, Your
Yes.
Lordship.
The learned government advocate. Have you filed your counter? CGC,
I followed it.
the learned government advocate, has prayed for time to file the counter affidavit. Mr. So what were you mentioning?
The only matter is the rate appeal matter. This question of 28 interest is concerned. There was a rate petition, it was dismissed, and subsequently rate appeal is there. Rate appeal matter.
The learned CGC
Rate appeal matter.
further submits that there is a similar matter which is pending before the division bench, is it?
Here, yes. Rate appeal 8 of 24.
Registered as writ appeal number
8 of 24.
8 of 2024, which is still pending, and prayed that the matter be taken up after the disposal of the said writ appeal. In view of the above submissions, list after, make it 4 weeks. Then in the next one, item number 5, Mr. Jonathan El Silo, learned counsel for the petitioner is present, along with Ms. Zairam Sanghui, learned CGC for.
Deleted from the post list.
Pardon?
My name may be deleted from the post list.
Okay.
Item number 4 and 5. If my learned friend will defend the case.
In 4, it is Mr. S.K. Medi, isn't it? Now in 5, it is Ms. Zairam Sanghui. So Zairam Sanghui are appearing in 5. There are 2 different cases, isn't it? Well, Ms. Zairam Sanghui, learned CGC, appears on behalf of respondent number 4 to 7. Along with Ms. Vanesiami, learned government advocate for respondents number 1 to 3. Have your pleadings complete?
Yes, Your Lordship.
Yes, Zairam Sanghui, have you filed your counter?
My learned friend will defend the case.
No, this is for item number 5. He's saying he's appearing only for item number 4. So item number 5, your name is already there.
4 and 5 is similar, my lord. Anyway.
But it's a different case, isn't it? Issue is same, but you're representing, but the councils are different. Let me see the previous order. So now, since Mr. S.K. Medi is appearing in for the item number 4, you're saying issue is the same. So Zairam Sanghui, you're saying that you will not appear, or what? What is your submission? Or you're appearing?
My learned friend submitted that he will be appearing for the oral respondent. In the meantime, I didn't receive any comment in this case.
Okay.
Then, appearing.
Wait, let me see. Counter affidavit, counter affidavit. So now counter affidavit has not been filed by the Union of India, is it? Yes, 2 CGCs, so anyone can appear. Same, you're representing the. Mr. S.K. Medi, you're saying you're appearing. Have you got instructions to appear in this case? So Zaram Sangpu, you will have to appear. If you had received you were representing the respondents before. Well, Ms. Zaram Sangpu, what is the order? Anyway, Ms. Zaram Sangpu appears on behalf of, I think I've mentioned, okay, along with Ms. Sosa. The learned government advocate submits that they have filed their counter affidavit, while Ms. Zaram Sangpui, learned CGC, submits that she has yet to receive instructions in the matter, full stop. Then similar matter pending, is it correct? She further submits that, is it so? In item number 5. Yes, Ms. Zaram Sangpui, in item number 5, do you know anything about the writ appeal?
Oh my God.
Then you pray for next date, isn't it? She has yet to receive instructions from the respondents. Number, yes, the same number, okay. To find out properly, respondents number 327. No, 427. 427. In view of the above submissions, list after 4 weeks. Yes.
Item 6.
May it please your lordships.
Yes.
Your lordships would recall this is that GST matter your lordships had issued notice regarding late filing of one GSTR 3B form leading to a liability of 12 crores, my lords.
Yes, so affidavit on behalf of respondents number 1 to 6. That was
Yes,
the
Lordship.
last submission.
Yes,
So have
I
you
have
filed?
already, yes, I've already filed on last
Okay,
week
fine.
Friday, if I'm
So
not
pleadings
mistaken.
complete?
My lords,
Completed
Or you want to
Lordship.
file rejoinder?
no, my lords, rejoinder may not be filed because, my lords, the coordinate benches have already, my lords, issued judgments on this issue. My lords. I have those orders.
Okay. So you give a copy of this, say it's a covered matter.
Yes.
Okay.
Lordship, I may be given that judgment, then I will examine,
okay.
and if it is covered, then we
My
have
lords,
nothing
it's
to
already
say.
mentioned in the petition. My learned friend has replied in his counter. In fact,
On those.
his counter himself can be relied on to dispose of the matter today, my lords. Unless your lordship,
Where are the judgments?
my lords,
Is it
may I-
here?
My lords, if I may pass.
Or we'll fix a short date for admission hearing and give a copy of the judgment,
Yes, I
isn't it? Heard Mr. What? Short judgment?
Very short notes, just 2 pages. Because, my lords, the amendment has come in the act. They themselves in the counter says, they see that if the amendment is allowed, it should be allowed.
You have to give the background of the case, that's the whole thing, yes,
My
anyways,
lords, the
yes.
judgment that I have passed,
Uh,
your lordships, this would in fact give you a background, my lords.
okay, fine. Yes,
Your Lordship,
please
if I
read
may-
the judgment.
Para 2, my lords. In this petition under Article 226 of the Constitution of India, petitioner has challenged the correctness or otherwise of the notifications dated 17/8/17, 10/9/18, 9/10/19. We've challenged the same exact notifications.
Okay, same notifications?
Yes, my lords.
Okay,
And the proceedings and order dated so and so. So, my lords, this similar order was passed in us. The date is different.
okay,
Whereby the demand of CGST and SGST amounting in aggregate to so and so, in terms of Section 73 of the Act, read with relevant sections of the Arunachal Pradesh GST, stands confirmed. And the demand of interest at appropriate rate under so and so, Section 50 of the Act and Section 50 of the State Act, stands confirmed, by which a penalty of rupees so and so was imposed in terms of Section 973 read with corresponding provisions. Mr. Jain, learned counsel for the petitioner submits that during the pendency of the writ petition, the respondent authorities have brought amendment in the Section 16 of the CGST Act, White Gazette Notification 16/8/24, with retrospective effect from 1st July 2017 by inserting subsection 5 in Section 16 of the CGST Act, and that in view of the aforementioned amendment, the impugned order may be set aside and the matter may be remanded to the respondent's authorities to consider and pass appropriate orders taking into consideration of the provision subsection 5 of 16 of the CGST Act White Gazette notification. My lords, in para 2, the last line, and thereby the benefit of input tax credit is denied. This is the same issue. It's all because of delay. Para 4 says, my lords, Mr. Boro, learned standing counsel for respondents in the CGST, submits that in view of the recent amendment brought in White the Gazette notification.
It has retrospective effect,
Yes,
isn't
my
it?
lords. Now a fresh exercise is to be carried out by the respondents under the new subsection 5 of section 16 of the Act. Having heard submissions of learned advocates of both sides, I have carefully gone through the petition and the documents placed on record, and also perused the impugned order dated 19/12/2023. I have also perused subsection 5 of 16 of the Act, which reads, notwithstanding anything contained in subsection 4, in respect of an invoice or debit note for supply of goods or services or both pertaining to the financial year 17-18, 19-20 and 20-21, the registered person shall be entitled to take input tax credit in any return under section 39, which is filed up to the 30th day of November. My lords, it was before September of every financial year. They had retrospectively, my lords, changed this. Taking note of the submissions of learned advocates on both sides, and also considering the amendment brought in section 16 of the Act by inserting subsection 5, impugned order dated 19/12/23 stands set aside and quashed without, however, adjudicating the same on merit. Now the respondent authority has to carry out fresh exercise and pass appropriate order, taking into consideration the provision of subsection 5 of 16, brought by the amendment so and so.
So
Your lordships,
if the facts and circumstances the
Same.
same, yes.
Same, my lords. In fact, in our writ petition at para 98, we have stated this. This particular petition is there before the coordinate bench.
Where,
They
where?
then, my lords, para 98 of our writ petition. Page 50. Lordships has it.
Para?
98, page 50.
What does the para start? What does
That is honorable court. That is para 98 of page 50. 50.
Yes.
At the that this honorable court, Itanagar bench, has itself in writ petition C-163 of 24 and 552 of 2023 was pleased to consider the same lists as raised by the present petition and issued notice in the matter and granted interim stay in the matter.
So accordingly, the said writ petitions were disposed by
Yes.
this order.
And they themselves don't deny that. It's in their counter. And if I may just take your lordships through one paragraph of their counter. Lordships, this is the counter which was recently filed of respondent number, my lords, 8.
Respondent number 1 to 6?
1 to 6, sorry.
Yes.
My lords, here, the case itself, my lords, briefly put is at para 10. May I read, my lords?
Yes.
Para 10, they say, with regard to the statements made in para 30, the show cause notice was demanded for recovery of ineligible income input tax credit taken by the noticee during the tax period 2018-19, 19-20 and 2021 in terms of section 73(9) read with section 16(4) of the CGST Act and similar provisions under the Mizoram GST Act and section 20 of the IGST Act. There was no modification or amendment for waiver or putting aside of the provisions given under section 16 of the CGST Act. The submission of the petitioner in this para cannot be considered for withdrawal of the SCN and order in original. So, my lords, this is the case in crux. Because I have filed my GST form 3R belatedly, they have said you are not eligible for the input tax credit. Now, my lords, your
But now there's an amendment. Yes.
Now, my lords, your lordships would see page 14 of this present counter at para 959. That with regards to statements made in para 229, the answering respondent submits that consequence upon the 53rd GST Council meeting, an amendment of section 16 of CGST Act was effected, according to which it was inserted that in respect of an invoice or debit note of supply of goods or services or both pertaining to the financial years 17, 18, 18, 19, 19, 20 and 2021, the registered person shall be entitled to take input tax credit in any return under section 39 which is filed up to the 30th day of November 21. The related ITC pertaining to financial year 2018 and 19 as presented by the applicant appears to be going to be allowed. Because my
Appears to be going to be allowed.
Because, my lords, at the time when we had filed, it was only a GST Council recommendation. The amendments came later. Similarly, for the, this is, my lords, the years covering 18, 19 and 19, 20. For the year covering 2021, your lordships may have the next para. The above amendment also inserted that where registration of a registered person is cancelled under section 29 and subsequently the cancellation of registration is revoked by any order either under section 30 or pursuant to any order made by the appellate authority or the appellate tribunal or court, and where availment under subsection 4 on the date of order of cancellation of registration, the said person shall be entitled to take the input tax credit in respect of such invoices or debit note for supply of goods or services or both in a return under section 39, filed up to 30th day of November following the financial year to which such invoice or debit note pertains, or furnishing the financial year to which such invoice or debit note pertains, or furnishing of the relevant annual return, whichever is earlier, or for the period from the date of cancellation of registration or the effective date of cancellation of registration as the case may be, till the date of order of revocation of cancellation of registration, where such returns is filed within 30 days from the date of order of revocation of cancellation of registration, the related input tax credit pertaining to the financial year 2021, the related return of which was filed on 11 July 2022, because, my lords, our order of revocation came in 1st July 22. It's in the list of dates. We had filed it thereafter within 11 days, 10 days on 11 July, which was within 30 days from the date of revocation of the cancellation of registration as submitted by the applicant, also appears to be going to be allowed.
Appears to be, so now it's
They
allowed.
themselves admit, my lords.
Oh.
My lords.
So I think it's covered. We'll dispose of accordingly. What do you have to say? And there is a judgment of the coordinate bench of this court, unless you say that the facts and circumstances are different and it cannot be covered, that's a different matter. But if the facts and circumstances
Also, that may be true, but
of the petition which is filed is the same, then
I may be allowed, Lordship. The petitioner had filed the input tax credit after the expiry of the due date of the availing such credits. May take Lordship to page 249 of the writ petition, Lordship, which 249. 248 is the summary of show cause notice, and the relevant is at page 249.
yes,
Lordship, this is the
this is it. Yes.
yeah, Lordship. this
249 of the writ petition, isn't
Lordship,
it?
yes,
Ah,
yes. It's
249,
this column number 1 is financial year,
yes.
month. Here, Lordship,
2020,
due date, yes,
yeah.
due date for availing credit. That is, a due date is 20/10/2019, and date of filing of the ITC was on 9/11/2019. So, which is after the expiry of the due date, Lordship, and that is the reason why show cause notice was issued to the petitioner. Show cause notice was issued on 20/12/2023, Lordship. Also, then there's a the second one is financial year 2019-20, and date
Even
due
then-
date, yes. So the petitioner had filed all the returns after the expiry of the due date, Your Lordship. That was the reason why the show cause notice was issued. And the show cause notice was replied by the petitioner, and the reason projected by the petitioner was rejected. And thereafter, order in original dated 10/4/2024 was issued, Lordship. Order in original was on 10/4/2024. So, Lordship, at the time of issuing the show cause notice and IOI, there is nothing wrong on the part of the respondents, because there was no amendment, frankly speaking, Lordship.
So, but
And
after the amendment.
Yes, let me come to that point, Lordship. Then after the amendment has came very late. So after issuing the show cause notice and order in
But
original,
amendment, it's given retrospective
retrospective
effect.
effect, Lordship.
So then it covers his
yes,
case,
Lordship,
doesn't
this,
it?
from the perusal of the writ petition, I have gone through, but I have not seen the coordinate bench of this court. That's why I'm saying that.
Okay, the
maybe-
judgment of the
yes,
coordinate bench.
Lordship. Then from the plain reading of the.
Give the copy
this-
of the judgment of the coordinate bench.
yes, Lordship,
Give
I have
him.
received. Then I may
It was
go through
read
them.
out also in the court.
And then maybe tomorrow or day after tomorrow, Lordship, I will discuss the matters with the we can dispose of.
May I just make one submission? My notes, this judgment that I've produced, the first orders which were passed in those cases, my notes, they were already part
Similar.
of the petition. That annexure is there, issuing notice. This, my lords, because it has a very consequential effect on the business of the petitioner, my lords. At base.
We'll give him time to read through. We'll list it tomorrow.
Tomorrow, Lordship, then I'll discuss with the department.
He wants
head
to
of the
discuss with
department.
his client before
Yes, yes.
disposing of, but see, if it's a covered matter
Lordship, yes.
and you're not planning to, you're not going to prefer an appeal, then we'll have to see, unless you say that we're going to prefer an appeal or whatever, and
I understand, Lordship.
then,
Then it may be listed tomorrow.
but
then I'll,
on what grounds will you appeal when there's an amendment?
I understand.
Which has got retrospective effect, so it covers your case,
Lordship, yes.
isn't it?
Lordship, yes.
So see the date, the retrospective, retrospective effect that it is the date.
Very true,
And whether that date covers the case of the petitioner. It's only that point you have to see.
Lordship, yes.
Tomorrow is DB day,
Oh,
but I
day
think,
after. Day after.
If your lordships can take it,
but after
But
the
we don't know
DB,
how
the
long it will
afternoon, we will dispose of cases which can be disposed.
No
We'll this
problem,
thing tomorrow.
Yes, yes, Lordship.
Heard Mr. Jordan Rohington, learned counsel for the petitioner. Also heard Mr. Johnny L. Tautong, learned counsel for the respondents. On hearing the submissions made by the learned counsels, list the matter tomorrow's date for further hearing.
Order here.
grateful, my lords.
Item 7.
My lord, some moments ago, order was passed, same councils, at item 2. Similar order can be passed in the present case. I mean, item number 7, 8, 9, and 10.
Okay, we will admit the writ petition, and then maintainability is also questioned here.
My lord,
Okay, same order as that passed in
I got
item number 2.
2.
Yes, my lord.
7, 8, 9, and 10.
So it's going to be listed for hearing.
Yes, my lord.
16.
Have we fixed 16th?
Yes,
For
ma'am.
the- Okay,
Yes,
on
ma'am.
16th,
My lord.
same order. Yes.
Obliged.
Item 11.
Orders.
Yes, what is the matter about?
My lord, yesterday the
Oh,
respondent.
mediation.
Yes, yes. Respondent number 1.
Instructions. So what happened?
Yes, Your Lordship,
Yeah.
we have taken the instruction and we have come into conclusion that we'll do the
Okay,
mediation.
willing, okay. Third, Mr.
But Your
Singh.
Lordship, a little request, Your Lordship, if this mediation could be had in a very early date, as soon as possible.
Mediation, they'll fix. You can talk to the secretary mediation to fix early date. Okay. Heard Mr. C. Lalthianglima, learned counsel for the appellant. Also heard Miss
Okay, Venetia.
So-and-so appearing on behalf of her senior. Is her name there in the cost list?
Yes, Your Lordship.
Okay, also heard Miss So-and-so, learned counsel for the private respondent number 1. the learned counsels submit that the parties are willing to have their matter referred to mediation and make an attempt to come to an amicable settlement. In view of the above, matter to be sent for mediation, full stop, registry to do the needful.
Hearing item 5.
It's fixed for hearing? Yes. Oh. Councils had come yesterday saying that hearing. Ms. Adam Sangpui was also here. What happened? Anyway, none appeared for the parties on call. List the matter after 2 weeks. I think you all forgot because the senior counsel, Mr. A.L.H. Yanshima, was also here. Yes, his junior is here. Item number 5 was fixed for hearing, today's hearing. What happened?
My lord, I was informed that the learned council, the government council has some difficulty, my lord.
Okay, so instead of none appeared for the parties, say that Ms. Ruth so-and-so appears on behalf of her senior, Mr. L.H. Lianshima, learned senior counsel for respondent number 2, and submits that they have been informed that the learned government advocate
Yes, my lord.
will not be able to appear in this matter. He has therefore prayed for adjournment. In view of the above, list after 2 weeks.
Obliged.
Yes, what happened? Now, in such cases, if they don't appear immediately, usually you have the person sitting here, they can come in.
Yes.
But you have sent him away. You should have sent him away. If there's some problem,